Hello friends, welcome back to ixamBee. This is Vidhika and today in this video we are going to continue with our part 4 of Important MCQ series, and here we will discuss questions from Companies Act 2013. This Companies Act, company law, is very important for all the exams, for all law officer exams. So without wasting time, let's begin with our first important question. What is the minimum and maximum number of directors required in a public company as per the Companies Act 2013? The correct answer here is minimum 3 and maximum 15. This is clearly mentioned in section 149 of the Companies Act, which lays down that the public company shall have a minimum of 3 directors and a maximum of 15 directors, provided that a company may appoint more than 15 directors after passing a special resolution. Second question is, how long shall the books of amalgamated company be maintained? So the answer here is on the central government's permission. This is clearly stated in section 239, which states that the books and papers of a company which has been amalgamated with or whose shares have been acquired by another company under this chapter shall not be disposed of without the prior permission of the central government. Moving on to our next question. In case of a private placement, the securities are offered to a select group of persons. What is the upper limit to the aggregate number of persons who can be offered to subscribe under private placement in a financial year? The correct answer here is option D, 200. Private placement means any offer or invitation to subscribe to a select group of persons by a company other than by way of public offer through private placement offer cum application, which satisfies the following condition. So in private placement, an offer or invitation is being given to a select group of persons based on the following conditions. Those select group of persons should have been identified by the board. They should not exceed 50 or such number as may be prescribed, and that prescribed limit as of now is 200 persons in aggregate in a financial year. However, this excludes QIBs and the employees of the company. Moving on to our next question. What is the minimum number of directors required in a private company? The correct answer is option A, 2. Section 149(1) of the Companies Act 2013 requires that every company shall have a minimum number of 3 directors in case of a public company, 2 directors in case of private company, and 1 director in case of one-person company. Question number 5 is, exception of Doctrine of Constructive Notice is. So which of the following is an exception to Doctrine of Constructive Notice? The correct answer is E, none of the above. Let's understand this by the explanation. In companies law, the Doctrine of Constructive Notice is a doctrine where all the persons dealing with the company are deemed or construed to have knowledge of the company's articles of association and memorandum of association. So what Doctrine of Constructive Notice means? It means that all the persons who are dealing with the company directly or indirectly must be aware, must have knowledge of the public documents of the company. For example, Article of Association, Memorandum of Association. These documents are placed by the company in the public domain for anyone to access them. So the Doctrine of Constructive Notice is based on the presumption that any person which is dealing with the company will have access to these articles, will have knowledge of these documents. The doctrine of indoor management is an exception to this rule. So what is doctrine of indoor management? That means the persons dealing with the company cannot know what happens inside the doors of a company, and it is not even in their concern or ability to get it checked or confirmed. So the doctrine of indoor management protects the outside people, the people who are outside, from any wrong or fraud act which is done by the company. So all the options given above, option A, knowledge of irregularity, suspicion of irregularity, or forgery, they are the exceptions of doctrine of indoor management. Moving on to our next question. What should be the time difference between 2 consecutive meetings of the board? The correct answer is C, not more than 120 days. The meeting of the board of directors should be held in such a manner that not more than 120 days shall intervene between two consecutive meetings of the board. This is clearly mentioned in section 173. Question number 7 is ABC are directors of a company ABC Ltd. Who among the following is a related party as per Companies Act 2013? If you look at the options, the correct answer is E, all ABC. What is a related party? A related party is a party related to a body corporate or company in any other way than by company's own transactions. So those people are related to the company by any other way. It means that a special relationship persists between the parties even before the transaction takes place. Section 276 of the Companies Act 2013 defines a related party with reference to a company to mean director or key managerial person or their relatives, a firm, private company in which the partner, director or manager or his relative is a partner, a private company or a public company in which the director or manager is a director and holds along with his relatives more than 2% of his paid up share capital. So moving by part 1 of the definition, A, B, C are here the directors of the company. So anyone who is related to A, B becomes a related party. And then we have another provision, key managerial position. So in option C, we have D, who is the company secretary. He has key managerial position. So his relative also becomes a related party. Our next question is, which of the following is not a type of debenture allowed to be issued by a company? The correct answer is C, debenture with voting rights. Debenture represents debt or borrowed capital. So debenture is equivalent to the term loan. It has an obligation to be repaid. As per section 71 of the Companies Act, no type of debenture can have voting rights. So which of the following is not a type of debenture allowed? Debentures with voting rights is not allowed as per section 71. Next question is, which of the following statements are correct with respect to payment of dividend? First, equity shareholder have the first right in matters of payment of dividend. Dividend for preference share is cumulative in nature. Third, compulsorily convertible debentures receive dividend at a higher rate than equity shares. The correct answer here is none of the above. None of the given statement is correct. Why? There are two types of shares, preference and equity shares. What is the difference between two? The word clearly specifies that preference shares will be given preference in their payments. According to section 43, persons holding preference shares are assured of preferential dividend at a fixed rate. Preference shares usually pay cumulative dividends but not always. So here we have our second statement being false. Equity shares do not enjoy preferential rights in the matter of dividend or repayment of capital. They have the last claim on dividend and repayment of capital. CCDs, compulsorily convertible debentures, are debt on which interest is paid by the company and not the dividend. Hence, statement 3 is wrong. Our last question is, the constitution of NCLT led to dissolving of which of the following entities? As is marked, the correct answer is Company Law Board. It was dissolved when NCLT was formed. Following the constitution of NCLT and NCLT, the Company Law Board was dissolved. Provisions for NCLT and NCLT were notified on 1st June 2016. So this is all that I have brought today from Companies Act. This is a very important act for all the exams, for all law officer exams, and also it is a bit cumbersome act. So you should have awareness of what is important in this act, what is not, where to focus on, and also practice a lot of questions so that you are able to apply your theory, you are able to apply your knowledge and understand how much you have retained. ixamBee provides you courses in all these exams. For all law officer exams, we have expert legal faculty to help you prepare, to guide you at every level of your preparation. ixamBee makes government exams very easy. Do subscribe to ixamBee channel to get all the updated information about government exams. Click on the bell icon. Thank you.